But the award of rights to A includes an express stipulation that for every 5 trees felled by A, 1 tree goes to the government to be sold off and devoted to some entitlement program. This term was known to all parties beforehand. It was part of the auction process. It was part of the terms on which A made its bid. Now, A goes in there and it chops down its first 500 trees, and the government says, okay, we're taking our 100. And Company A refuses, claiming to be shocked and outraged, saying that such redistribution of wealth, taking from A and giving to B, is unjust and illegitimate. So what are you going to say to A? I assume most of us will not agree with A. There is redistribution here, redistribution of trees, but not, I mean, when the government goes in and takes its 100 trees, but not redistribution of wealth in the sense in which the anti-redistributionist has in mind. Because A never had a right. A never had a right to all the trees. It only had a right to 80% of the trees. Pretty clear, right? No redistribution. Will you grant me that? I hope you will. Of course, what might seem to make this hypothetical easy and to distinguish it from real cases of redistribution, one might say, is the fact that we're starting with trees that are on public property. I said the trees are on public land. That's what makes it an easy case. Of course, the government can reserve a right to 20% of the trees when it bids out the auction process. Why not? They were the government's trees. It's got to be different, doesn't it? Someone will say it's got to be different when the government just reaching in and taking property, let's say, from privately owned land and redistributing it. Well, maybe, but the targets of classic anti-redistributionism, like liberal entitlement programs and progressive taxation, are, I'm afraid, very little different from the case of these trees. Why is that true? Well, let's take an intermediate case between public land and private land. Let's take intellectual property. Let's say someone has written a novel called Harry Potter and the Philosopher's Stone, or whatever the original title was. It turns out to do rather well. The author makes money. But more than that, the sequels to this novel and the movie versions to the first and all the rest of them, the whole series, happen to be worth over $1 billion. Just one question: who has the right to produce these sequels and those movies? Is it the author, or can anyone write Harry Potter sequels and make Harry Potter movies? The answer under our law is that the exclusive right to produce the sequels and the movies belongs to the author. The exclusive right. Anybody else tries to write an unauthorized sequel, she, J.K. Rowling, can go and stop it, have the publication enjoined. Anyone else tries to make a movie, unauthorized movie, she can have it stopped. She and she alone has the right to do all that. But wait, how'd you get that right? The right is created by positive law, and quite recent law at that. Used to be quite recently that anyone could write a follow-up novel, a sequel using the same characters, but in a new story. Henry Fielding did just that. Used to be that anyone could transpose an existing story into a brand new medium, such as stage or screen. William Shakespeare did that all the time. It's the state that gives these lucrative derivative rights to the author for a limited time. To be sure, there have always been those who said that authors have all these rights as a natural law matter. Mr. Herbert Spencer, in a book called Social Statics, made just that argument. You remember Social Statics, the one that Justice Holmes said the Constitution did not enact in the Lochner case? But I'm prepared to grant that authors have natural law rights to their work. I'll grant that. I like the idea a lot. As a matter of fact, being an author myself. Sadly, nobody's told me where the address is of the natural court that's going to enforce these natural rights. I only seem to be able to find real courts, and real courts enforce real law, positive law, and that's what makes the author's derivative rights valuable, that a real court will enforce them. It's positive law that gives authors their billion-dollar copyrights, and it does so with the purpose, at least according to the usual story, of creating incentives for the production of creative work for the benefit of us all. Now, if that's right, though, let's say that the state, when giving this very lucrative, positive right to the author, includes an express stipulation saying 20% of the income goes to us, like 20% of the trees. 20% of the income goes to us to spend on whatever programs we like, including food stamps, pick your entitlement program, whatever it is. And now let's say when the author starts making money from these derivative rights and the government demands its share, 20%, the author says, this is an outrage. It's taking from A and giving to B. Now what do you say at that point? Can we change our answer this time and say, no, it is redistribution this time, even though it wasn't in the logging case? I don't quite see how we can. Surely it can't make a difference that the government has put its tax code in one statute book and the copyrights in another statute book. If that's a problem, that's going to be a pretty easy one to solve. The author never had a right to all the income from the derivative rights, just never had a right to it, not from the beginning. And that's why there's no redistribution in that case. Now, at this point, some of you in the audience may be starting to get a little nervous, but at least you'll say it can't apply to real property, real land, real tangible property, this argument. Well, I'd say you're right to be starting to get nervous, but yes, it can apply to real property. It applies to all property, this argument. It's child's play to extend it. I'm buying, let's say, or you're buying a condominium in New York City. You know what the taxes are going to be on that. You're well aware of them when you buy it. It's factored into your price. If you're looking at a unit that, for one reason or another, is exempt from the taxes, I'm talking about taxes when you resell it, transfer tax. I'm talking about taxes on your income if you rent it out. You know what they are, and that factors into your price. You'll pay a high premium if you're looking at a unit that isn't. Okay. So, I know why he wants me to wind up, but so you factor those taxes into your price. And when you buy that condominium and the government comes and asks for its share, its tax, can you at that point say it's an unjust and illegitimate act of redistribution? Well, if the argument, though, so far was right, I don't think you can. I think you never had a right to all the income. You're just like the logging company. Now, if that's right, then there is no redistribution. There is no redistribution. In cases of standard progressive taxation, liberal tax and transfer, the only thing remaining would be midstream changes, increases in tax after rights are acquired. And since there's a gentleman standing just to my left, I think I'm going to hold off what I would want to say about that until later. But, of course, happy to take questions, as any academic would be.
I'm going to try to limit the time of some of these opening statements so that we can really get into it and the panelists can become pugilists. Richard Epstein is a visiting professor at NYU. He's a distinguished professor of law at the University of Chicago, where he's taught since 1972. He's a senior fellow at the Hoover Institution. And I won't go through all the different things he's done, but I can't resist this. This is my standard introduction of Professor Epstein. He has taught courses in civil procedure, communications, constitutional law, contracts, corporations, criminal law, health law and policy, legal history, labor law, property, real estate development and finance, jurisprudence, labor law, land use planning, patents, individual estate and corporate taxation, Roman law, torts, workers' compensation. And Richard, if you want a short introduction next time, you're going to have to list the courses you haven't taught rather than the ones you've had. Come on up here.
Thank you. Actually, I missed antitrust, administrative law, and environmental law, but and a couple of others, but nobody much cares about all of that.